Today, we will talk about the subject of fiduciary definition, examples, and why they are important. A fiduciary acts on behalf of another person, putting their client's interests ahead of their own, with a duty to preserve good faith and trust. This legal and ethical obligation applies to money managers, financial advisors, bankers, insurance agents, accountants, executors, board members, and corporate officers. A fiduciary's duties are both ethical and legal, requiring them to act in the best interest of the principal they represent. In many cases, a fiduciary cannot profit from their position without explicit consent from the principal. Fiduciary duties appear in various business relationships, including estate arrangements, corporate board memberships, and investment management. A trustee must make decisions in the best interest of the beneficiary and is an essential aspect of comprehensive estate planning. Politicians often set up blind trusts to avoid conflict of interest scandals, where a trustee invests on behalf of a beneficiary without the beneficiary's knowledge. Corporate directors have specific duties, including the duty of care, the duty to act in good faith, and the duty of loyalty to the company and its investors. Breach of fiduciary duty by a board member can lead to legal consequences. A fiduciary deed is used to transfer property rights in a sale when a fiduciary must act as an executor of the sale on behalf of the property owner. The fiduciary is required by law to disclose the true property condition and cannot receive financial benefits from the sale. A guardian is appointed by the state court when the natural guardian of a minor child is not able to care for the child any longer. The guardian is tasked with ensuring the minor child or ward has appropriate care in various aspects of their life, including education and daily welfare. The attorney-client fiduciary relationship is one of the most stringent, requiring complete fairness, loyalty, and fidelity in each representation of, and dealing with, clients. Attorneys are held liable for breaches of their fiduciary duties by the client and are accountable to the court in which that client is represented when a breach occurs. In a principal/agent relationship, an agent is legally appointed to act on behalf of the principal without conflict of interest. Examples include shareholders electing management as agents and investors selecting investment fund managers as agents to manage assets. An investment fiduciary is any person who has the legal responsibility for managing somebody else's money. This can include volunteer investment committee members, who are bound by a position of trust and may face consequences for the betrayal of that trust. Broker-dealers are generally compensated by commission and only have to fulfill a suitability obligation, which requires them to make recommendations consistent with the needs and preferences of the underlying customer. The duty to disclose potential conflicts of interest is not as strict a requirement for brokers, leading to potential conflicts between brokers and clients. Investment advisors are bound to a fiduciary standard and must put their clients' interests above their own. Broker-dealers may not share the same fiduciary responsibility, as they are regulated under the suitability standard and have a primary duty to their employer. The U.S. Department of Labor fiduciary rule proposed changes to toughen requirements for brokers dealing with retirement money. The rule has faced implementation challenges and legal battles, with its future under review. The possibility of a trustee or agent not optimally performing in the beneficiary's best interests is referred to as fiduciary risk. Fiduciary abuse or fraud occurs when someone misuses their authority as a fiduciary for personal gain or to serve their self-interest. Fiduciary liability insurance is available to protect individuals who act as fiduciaries of a qualified retirement plan, providing financial protection in cases of litigation arising from mismanagement of funds, administrative errors, or other circumstances. To assist investment fiduciaries, the Foundation for Fiduciary Studies was established to define prudent investment practices. These include steps to educate fiduciaries, formalize an investment program, implement investments, and monitor investment performance. Here are 5 key takeaways. 1. A fiduciary is legally bound to put their clients' best interests ahead of their own. 2. Fiduciary duties appear in a range of business relationships, including a trustee and a beneficiary, corporate board members and shareholders, and executors and legatees. 3. An investment fiduciary is anyone with legal responsibility for managing somebody else's money, such as a member of the investment committee of a charity. 4. Registered investment advisors and insurance agents have a fiduciary duty to clients. 5. Broker-dealers just have to meet the less stringent suitability standard, which doesn't require putting the client's interests ahead of their own. Hope this would help. Thanks for watching.